Okay, good afternoon. This is Richard Hsu, host of Hsu Untied. Today, I'm very thrilled to have with me as my guest, Andy Gass, who's a partner at Latham. Andy, welcome to the program.
Thank you so much for having me. It's a pleasure to be here.
So, Andy, let me start by asking you, how does a Yale College undergrad in anthropology decide to go to law school in the first place?
After trying a lot of other things first is the short version of that story. I had absolutely no intention of being a lawyer, but it was really through the process of elimination that I wound up, trying to be a musician, a small business owner, working for a nonprofit, and then sort of threw in the towel and relented to the overwhelming force of the draw of law school.
Well, where did that overwhelming force and draw come from? Your parents, or where did it come from?
Oh, I don't think so. I think I'm the kind of person who, from the age of like 10 years old, the most people I met sort of looked at me and said, that kid's going to be a lawyer. So I resisted it for many years, but knew ultimately it was probably not a bad idea. And I think I chose it honestly for the diversity of choices that it would afford. I even then had no intention of being a practicing lawyer at a law firm, but I was interested in sort of government work or public policy or academia. It seemed like there would be a lot of different things one could do with the degree.
Do you have any interesting or good stories about some of the adventures that you had after college, before law school?
Oh my God, there's so many. I mean, I just did a really wide variety of things, sort of many of them, kind of depressing to be honest. But let's see. I started a really ill-fated magazine with a guy who had been like a dissident in China. I spent a lot of evenings playing bluegrass music in bars in Somerville, Massachusetts at like 2 a.m. with 7 people in the audience. I gave a lot of talks sort of all over the country on behalf of a nonprofit I worked for called the Public Library of Science, which is a very misleading name because it was neither public nor a library. So I mean, God, it was my early 20s where I sowed some oats for sure.
Sounds like a whole separate podcast.
Yeah, exactly.
Well, tell me this. So you go to law school, and how did you end up having this very interesting technology IP practice that you have today? Walk me through a little bit of how that kind of evolved to be such the case.
Yeah, I think it was in large part a product of a commitment to just working on stuff that I was genuinely interested in for people that I really had a good working relationship with. And those were sort of the two guiding principles. When I was in school at the UC Berkeley Law School, I worked really closely with a particular professor there named Pam Samuelson, who is sort of a titan of the copyright bar in academia. And I took a lot of courses with her, studied with her, wrote some papers with her guidance, wound up going to a firm that no longer exists now after school, called Howard Rice, which subsequently became part of Arnold and Porter, where I worked for another one of your podcast guest, Hank Barry, for a year. So I was working for Hank doing sort of licensing work, and left that job to go clerk on the DC circuit, a clerkship that I had accepted while I was still in school, sort of for a year after graduation. So it was at that point that I really developed kind of a love for the litigation side of the law. I was one of those really lucky people to have a fantastic match in the judge that I clerked for, the late Stephen Williams. And from there, to be honest, I was so convinced that the clerkship was probably the high point of my legal career that I started looking for other things to do, just because it was inconceivable to me that anything could be as interesting as sort of the cases that we were dealing with at the time. These habeas petitions from Guantanamo detainees, and not to say nothing of sort of the administrative law stuff, which is the standard fodder of DC Circuit adjudication, which I'm a big nerd for. So I loved that job, sort of poked around at doing other things altogether, and then wound up taking a gig at Latham in San Francisco, again, sort of partly by accident and partly just because there were some people there that I really liked and respected. And so this was, back in 2010. And at that time, I think for people with kind of the general approach to the law that I had and sort of mindset, which is a pretty intellectual one, right? You sort of a hope that kind of being better, smarter, faster than the other guy is going to get you wins more than sort of being brutal and nasty. For people who sort of approached the law in that way, there was kind of a limited number of disciplines where you would feel at home. And I think appellate law was one of them, but you can't really be an appellate lawyer in San Francisco. I'm sorry to say for your listeners, it's not really a practice that exists meaningfully. But antitrust law at the time was the other big one. So, and it was just an area where the day-to-day practice of the law overlapped a lot with the academic research into the subject, and you sort of needed to stay up on the latest papers and thinking to be really good at working for clients in that area. So I came to Latham really to do that work. And was very lucky to fall in with a group of folks who I just had a really positive working relationship with. You know, those I had done enough things before I went to law school to know that just not everyone that I worked for or with would sort of meet the stuff that I put out with like, this is great, like more of that. So just finding some people where I had that really constructive, synergistic working relationship was incredibly valuable to me. Now, at the time I'm there practicing antitrust law, largely litigating cases for technology companies in that space. And I was a third year associate. So after my clerkship, I was there. And Professor Samuelson from Berkeley reached out to say she was going on sabbatical the following year. And would I be interested in taking over her copyright law class at Berkeley? So here I am, junior associate at Latham & Watkins. No idea if I'm actually allowed to do this or not. So I kind of take the elevator down to the 15th floor and march into the office of sort of the head of the practice that I was working for, a guy named Dan Wall, who has been subsequently awarded as like antitrust lawyer of the millennium. And I sort of, you know, sheepishly knock on the door and I let myself in and he says, what's up? And I say, well, the UC Berkeley Law School has asked if I want to teach the copyright law course there next semester. Like, am I allowed to do that or what's the rule? And he just sort of stares at me across his desk and he goes, what are they flipping through the phone book trying to find someone? And thank you, Dan, for that vote of confidence. I really appreciate it. I'll take that as a yes. So I wind up
classic.
I wind up teaching this course by evening as I'm like practicing law by day, and it was a crazy amount of work, right? Because it's not like Latham gave like credit for you know, teaching this course. And I think that first semester, it was a 3-unit course. It was 3 hours a week. I think I put in like 10 hours of prep per hour of lecture, honestly. It was just bananas. So, but you know, a really good way to learn a lot about a subject matter that you're interested in is teach it, because you've got sort of a bunch of lectures to prepare. You've got the fear of being asked a question from students who at that point were like not that much younger than me, which is a very strong motivating force, right? So, you know, I learned a lot about the law in that area. And what essentially happened, this is an extremely long-winded answer to what was a very simple question. What essentially happened was word got out at Latham that here was this, you know, junior and then mid-level associate who like knew an awful lot about this area of the law, where the firm didn't really have a dedicated practice at the time. They had sort of IP litigators, they had even sort of what they called soft IP folks, although that's a term that I kind of loathe, to be honest. But here I was, a very lucrative, leverageable source of relatively sophisticated knowledge and understanding about this stuff. So I kind of just started being the person to whom questions about copyright and technology sort of flowed. And one of the interesting things about sitting in that spot at a place like Latham, which is, of course, you know, one of the largest law firms in the world, but again, one that at the time, 2011, 12, people didn't really think of as a destination for this type of work. You know, if 1 out of every 45 clients has one issue in this space every 10 years, it's like an overwhelming amount of work. So what happens is just all this stuff kind of starts flowing through me, and I'm sort of answering these questions and sort of a little bit litigating in the area and so on. And at some point, I kind of decided that I need to figure out what I wanted to be when I grew up. And it was then that I kind of took a turn towards being a little bit more deliberate about building a practice in the space, which is a story that I can also tell at great length.
So tell me, so what actually is that practice? How would you what is that practice? Describe that to me now.
Yeah, so it's basically the version of a dedicated copyright practice that we collectively decided makes sense for a firm like Latham. Mm-hmm. And that description has all of those qualifiers because copyright law kind of, maybe not uniquely, but different from like white collar or antitrust or things like that. There's a lot of matters in that space that are just not going to make sense for an institution like Latham and Watkins, right? Smaller stuff where the stakes aren't that high. So what wound up happening was at some point, a little over 5 years ago, the firm set out to really systematically build a dedicated practice in the copyright law area. They had done that in the patent law space about 10 years before that. It was very successful, but they recognized that, just sort of allowing copyright law to happen to the firm rather than the firm having a proactive strategy to pursue cases in that area was probably leaving some opportunity on the table. So they basically wound up handing me the keys to go just sort of, build something that makes sense here and think about it carefully, right? Don't just be haphazard about it, but come up with a plan. And if that plan is, go hire the best free agent that you can off the street, that's great. We can be the New York Yankees and just sign the most expensive people. If that plan is to build a farm system, great. But, figure it out and let us know what you want to do. And I think importantly, the firm was very clear at the time, and this is sort of 2017, 2018, you've got a lot of freedom and leeway to do what you want, but just don't come to us after the fact and say that, the reason this didn't work is because you couldn't do what you wanted. We're telling you right now, like, build this however you think makes sense. Mm-hmm. And so that was what we did. And we had a lot of help from a lot of people, right? From IP folks, from antitrust folks, from others. There's a tremendous amount of support. And we basically wound up building a practice brick by brick from the ground up that really leveraged the firm's strengths and kind of my strengths, to be honest. So it's a lot of work for technology companies, for all of the familiar household names, Spotify, Apple, Amazon, those folks. A lot of work kind of in areas where copyright law tends to intersect not with other forms of IP like trademark or things, but instead where copyright tends to intersect with antitrust or administrative law or other areas where the stakes are likely to be pretty high and where we have a lot of relationships both within and outside the firm that are going to tend to be helpful in a kind of unique way for our clients. So again, another very long-winded answer to your question, but at this point, it's a dedicated copyright law practice representing, technology companies and largely other users of copyrighted works, although we do some plaintiff side work as well, really in matters where the complexity is high enough and the stakes are large enough that it's going to make sense for someone to try to seek out really a preeminent practice in the space rather than something that's a bit of a commodity practice. And I appreciate that that's an obnoxious thing to say, but it is in fact the truth.
Mm-hmm. So is the subject matter, the copyright subject matter, typically music that you're talking about, or does it include other things?
Yeah, so it's a lot of music because that is an area where there's just a lot of high stakes disputes, and there are some unique features of the law that make it so that there's recurring litigation in the space in a way that there isn't for other folks. And so there's really two kinds of cases in those areas. There's, is what technology company X is doing infringing the rights of sort of all the record labels and music publishers in the world, which is an interesting sort of species of case. Then there's another very unique kind of case in the music area specifically where a lot of the large scale music licenses that technology companies need, the prices are actually set in arbitrations or administrative processes or by judges under antitrust type consent decrees. So it's an area where the issues are sort of fantastically complicated. And it really helps to have a kind of robust background in antitrust economics. Mm-hmm. So it was a really natural home for us. And so we do a lot of work in that space. But the practice is much broader than that. We also do just a lot of run-of-the-mill copyright infringement work for technology companies. We represent Roblox, we represent Apple, and other folks. Just X that you are doing out there in the world is infringing my copyrights. Please stop it. And we can sort of be on either side of those cases. And then every so often, there's like a really fun, unique one that comes along. So next week, our group will be arguing a Supreme Court case over what's called the fair use doctrine in a case involving Andy Warhol's canonical rendition of the musician Prince. So just one of these fun ones that's kind of an offshoot of everything else that we do, and a great vote of confidence in our practice that we can do this stuff at kind of the highest level out there.
Now, does your work or does your practice extend to any movies and that sort of thing, or not typically, or what, or is that is that really kind of like a whole nother practice with different, very specialist practitioners?
No, it's a great question. So there is a fair amount of litigation out there over various sort of technical copyright stuff involving films. Most of those don't tend to blow up into like cases that are of the scale that it makes sense to engage us for. But every so often, we will absolutely work with a studio or someone who has released a movie and is accused of infringing some copyright. So all of that is out there. And I guess the last piece of the puzzle is that we are really actively building out sort of the licensing side of this practice, largely in the music space. So what we've found is that the same folks whom we work with at all of these streaming services and similar companies who are charged with defusing the disputes after they've arisen with the music rights owners, they're often quite interested in figuring out how to avoid the next round of disputes. And so for that reason, we're investing pretty heavily at the moment in just building out a really core expertise in helping technology companies kind of navigate the music licensing space well before anything close to a confrontation actually develops and arises.
Mm-hmm. Do you find yourself, is this an industry, is this a business where you have to kind of pick one side or the other? Like you always have to be on the side of the publisher, the distributor, or how does that kind of work in this space?
Yeah, so different verticals of our copyright practice have sort of different valences on that dimension. In the pure technology, non-music space, we've found that you can do sort of plaintiff side work, defense side work, it doesn't really matter. In the music space in particular, on the litigation side, you really need to pick a side. You're either on the side of the streaming services, or you're on the side and the technology platforms, or you're on the side of the rights owners. And so our practice is entirely on the litigation side, a music rights user side practice, whether that's radio stations or internet companies or sort of pure play music streaming services.
Got it. So now, and then in terms of your own personal interests, I mean, is it the litigation part that you really enjoy, or you're actually more on the advisory and a lot of the pre-litigation or the counseling or the negotiation side, or half? What is kind of your personal mix of the actual legal work you're doing?
Yeah, that's a great question. And I think that the answer is I'm really lucky to sort of get to do all of it and to kind of love most of it. So I think I'm at a stage of my career where the thing that I value most is the relationships, honestly, that we build with our clients and with the younger folks who are coming up. That's just incredibly rewarding to me. And one of the things that I've loved about the job of being a lawyer and litigator is that the job changes as you stay in it for many, many years, right? And so I started my career kind of writing briefs about esoteric issues. And then, over the years, you become more of a courtroom person and then really more of a relationship manager. And then at some point, more of a mentor than anything else. And so I've loved all of those roles. And I think it's sort of necessary to understand what goes into each of them to really be in a position to successfully manage a practice like ours. And I don't do that alone, right? We have lots of partners who sort of share that burden and responsibility with me and do the work and keep the trains running and engage in mentorship of our associates. But, I try to maintain a very healthy mix, of on the ground litigation, being the guy in the courtroom, arguing the motion, doing the cross-examination, all the way to, counseling the startup about, hey, if you built this product this way instead of that way, I guarantee you're going to avoid like a very expensive headache 5 years from now. So I love all of it and try to do all of it.
Do these cases typically go to trial or very rarely, or what would you say?
They go to trial a lot, actually. It's one of the really fun things about our practice is I think unlike a lot of other big law litigation practices, we've consistently had a couple trials a year since we built the practice. Some of them are arbitrations, some of them are in sort of strange administrative law forums, some of them are in federal court. But it's one of the great things and things that allowed us to attract, I think, some really top talent within Latham to our practice is that there's nothing like trial, and so we get to do that a lot.
Since you mentioned Hank very earlier, did you work on Napster at all when he was there?
So that was before I got to know Hank. So I worked for Hank in the rebound phase after that. But I started my career sort of on the transactional licensing side for him because what had happened was he obviously developed a significant expertise in understanding exactly what music licenses you do and don't need. And so at that point in his career, he was doing a lot of that work for sort of companies that were, this was like 2008 or something like that, for companies that were sort of just getting into the business of offering streaming services. And so it was an amazing foundation for me to sort of start my career by doing that pure transactional licensing work. And then, years later, wind up litigating those issues. And I should say, Hank was an amazing mentor and an amazing person to work for at that phase.
Are you a musician yourself by any chance or not?
I am. I played in bands all through college, and in fact, all through law school, I played in bands.
In guitar? What do you play?
Yeah, I'm a guitar player, and my taste in music is a little strange. I'm embarrassed to say I've played in what are now known as jam bands all through college, and then developed an unhealthy obsession with bluegrass music. So I played in a lot of bluegrass bands over the years.
You think your penchant in music kind of keeps, does that keep this stuff kind of more interesting, or?
I think it's all of it, right? I think that the music law stuff that we do, I mean, it's just kind of intrinsically interesting to me to understand sort of what is the paradigm that underlies all this stuff. And then the issues, again, they just tend to be really at that sweet spot between like hardcore, complicated copyright law and like inscrutable antitrust competition concepts. So it was sort of a dream combination for me.
Well, Andy, it sounds like you love what you do. Could you see yourself doing anything else in the future? Would you ever go back to teaching or doing something like that?
So I do teach. I still to this day teach at Berkeley. I have a seminar that I call Copyright, Competition, and Technology. And it sort of started out as a course in like the things that I hoped to build a career around, and has over the years become a course in what I actually do for a living, which is very gratifying. So I love that. I think ultimately though that I love the team sport aspect of being a lawyer and litigating cases in particular. And it'd be really hard to replicate that in academia proper, right? When I tell this to people, I love standing up in front of people and lecturing about concepts and cases that are really interesting, but that's not a full-time job for anyone, whether an academic or a practicing lawyer. So the question is like, what are you going to spend the rest of your time doing? And to me, as between sort of sitting alone in a room, like writing articles and working on big cases with clients and going to court, it's a no-brainer which one of those I would rather do.
Right. Well, Andy, it's been a wonderful conversation. I really appreciate your taking the time. I really enjoyed it. And if you happen to decide to do something else, please come back and tell me about it.
I won't be shy. Thank you so much. I really appreciate your time and attention.
This is Richard Hsu and Andy Gast. Thanks.